No, and it's not just that. I mean, we've seen it here now. You see the courts, the politicians, and the system as a whole, and it is enough to what's the word? Enough to discourage is the understatement of the year, but it's enough to cause people to lose faith. And
I understand that, and that's where I'm like, fire back, stronger and better than ever before. That's always the answer. The forfeiture is the only way the other side ever is guaranteed to win. But to be honest with you, it gives me more faith because these are not worthy adversaries. These are incompetent kids who just need to be put in timeout. And that's who we have running our country. And they just all need a timeout. I mean, when you have someone like Biden who gets one tough question and his response is, come on, man. I mean, you're like, this guy's president? This is an embarrassment for America. So we just got to keep hammering away at it. And I'll be doing that this week on Monday, file a Supreme Court petition for a little guy who stood up to the system, Michael Strickland. And the case will be Strickland v. Oregon. And I'll answer a question that a lot of people have because people through the years say, why file Supreme Court petitions when they're 1,000 to 1? The odds are 1,000 to 1 you'll ever get one granted. Now, if you dig through a lot of those, my view is it's closer to 100 to 1 because a lot of those are not really raising legal issues. A lot of them are pro se, things like that. If you're a prisoner and you have nothing better to do, you're going to write your own Supreme Court petition every time you get a chance. But you never know which one might sneak through there. You've had pro se petitions actually be granted by the Supreme Court. The Supreme Court likes to prove to the world who it can be in certain instances. Though my favorite ever, little brief tangent, my favorite ever form of relief requested was by a prisoner who requested specific relief. And his specific relief requested was for a certain, he went through each name of the people that he felt had screwed him over and railroaded him in the case to kiss his rear end. He wanted the judge to order them specifically to show up at a specific time and place to do so. And so the
I suspect that didn't go far. I saw one about a prisoner.
But he must have enjoyed writing it. He stuck in prison anyway, and it became infamous. I mean, there's it was because he used some other language you can guess to kiss his not just derriere. He used the more crude term. But it was right in the caption. So it was, please, specific relief for these people to kiss my. So I was like, well, why not? It's something you can only get away with in Boston legal. But what we're filing is this. The reason why I recommend filing it is, first, there's not many times you get to talk to 9 Supreme Court justices and 36 law clerks who are likely going to go on to be judges. Some of them Supreme Court justices, many of them law professors, some of them senators or congressmen. So these are some of the most influential people over the course of legal history that we deal with. So anytime I get a chance to write about a substantive, serious legal issue to them, I take that chance, even knowing that it's 1,000 to 1 whether I can sneak through and get my petition granted. The second reason is you preserve your argument for history and posterity. It's always there. I like to go and read old Supreme Court petitions from the 1800s. Third, you lay out a template to start you trigger a conversation and you lay out a template. I'll be putting this up on my site and the Free America Law Center place once we have it done on a website in order for people to cut and paste. So for lawyers across the country and then sometimes pro se people can see, okay, this is what the argument is. And anytime I have an argument that I think people can replicate and duplicate in their own arguments and their own defenses across the country at every level of court, I try to create the legal roadmap for that, the policy roadmap for that, using the Supreme Court petition to do so. There's no copyright claimed on it. And so they can cut and paste and have good arguments made and at least preserve those arguments from a legal perspective, but also begin to educate courts and lawyers and defendants all across the country about what their rights may be in this context. Because in this particular one for Strickland v. Oregon, what happened with Michael Strickland is, he's a little guy who was a photographer, videographer, freelance journalist, has a site called Laughing at Libs or Laughing at Liberals?
Laughing at Libs, I think. And we've done a few discussions on this during streams. I did a video on it. Strickland, yeah. So he's a small, skinny guy. He gotten assaulted at a previous event. Got a firearms weapon, legal carry. was being harassed at another event, chased, at some point I believe was assaulted, pulled out the gun, brandished it, pointing it down, said, "Get away, get away." Everyone lets him get away. He gets convicted on how many counts of, and for what?
So he'd been the prior victim of physical assault by people associated with the kind of people that tried to attack him that day. Based on that history of assaults and having his video equipment stolen from him and the rest, he got self-defense training, got his right to conceal and carry, learned how to brandish his weapon for self-defense. And on the day in question, a group of people who later admitted their goal was to beat him up or harass him, not have him present there.
They were seeing it in real time. I don't think there was no doubt about that.
Exactly. The were decided to try to attack him at a rally in Portland. And he's a little guy. I mean, Viva would look very intimidating compared to Michael Strickland.
And so I break 5'6" with shoes on, but I'm well built.
Yes, exactly. Yeah, and he's a guy that's a little bit on the spectrum. So this was a horrifying event for him to witness, and he tried to follow his training to a T, which was, okay, you walk back, you show them the gun, you don't pull out the gun. They kept walking forward. Okay, you pull out the gun, you show them that you have it, and then you put it away while moving backwards. That's all he did. Nobody was hurt. And because he successfully defended himself, he was arrested. He was charged with 17 crimes. He was charged with unlawful brandishing of a weapon. And at his trial, he was not allowed to introduce any evidence of his own state of mind, any evidence of the history of these people who had assaulted him, any evidence of his own history of being a victim by people like that. And so I took it up to the Oregon. I was hired after the trial, took it up to the Oregon Court of Appeals, showed the Oregon Court of Appeals that the judge's excuse, which was a misunderstanding of hearsay and other rules, simply didn't apply. They would ultimately recognize that, so they changed their standard. And they said, you know what? There's just no right of self-defense in Oregon unless I, as a judge, objectively would have done the same thing that you would have done. And so what that would do is completely gut the right of self-defense. There is no right of self-defense if the judge had to do the same thing, because no judge is going to say that. Almost every criminal prosecution is going to be some politically controversial case. What judge is going to say, yeah, I would have done the same thing they would have done? That's not going to happen. So it basically kills self-defense, period. And so I'm taking it up to the U.S. Supreme Court because an underappreciated aspect of the Heller decision, an undervalued aspect of the Second Amendment, in my view, throughout its entire history, is that the Second Amendment is not fundamentally about the right to bear arms. The Second Amendment is fundamentally about a particular method and means of effectively doing self-defense, whether it's from the citizen or from the state, another person or the state. And that's what it enshrines, and that's what the Heller Court rightly identified. The Heller Court said what the Second Amendment is really about is your right of self-defense, because that goes to the core of the social compact and why we even have government in the first place under the Lockean theory that our government was established under the predominant philosophical precepts that we created government. It was to defend one another against each other or against foreign enemies. And so self-defense is the core of it. And if you don't have a right of self-defense against another citizen, another individual, or even the state in certain circumstances, then the government itself is illegitimate. And so my view is the Second Amendment is there because using arms is the most effective means of self-defense, but it's not limited to being able to have a gun on your wall. It's in fact intended to be able to use or brandish that gun where necessary for self-defense.
It's, I mean, obviously we're preaching to the choir because I understand the argument. I know the case, not as well as you by any means, but I understand the case, and it's sort of a no-brainer that there can be situations where the exercise of self-defense is, on the one hand, so exaggerated, disproportionate, unjustifiable, outlandish under the circumstances. Like, you look at a 5-year-old kid and feel threatened and self-defend. Whereas in other cases, the subjective element is not just relevant, but almost critical. And to the extent it's not coupled with a gross overreaction and a gross use of excessive force under the pretext of self-defense, we're within the realm of reasonable interpretations under similar sets of circumstances. And to say that we're not going to factor in the subjective element in a criminal conviction, it seems to undermine one of the fundamental elements of criminal law on its face, which is the mens rea.
Exactly. So we're bringing that as also a due process violation under that it's basically watering down the intent requirement and removing it almost entirely. But really what it goes down to is making sure people understand the Second Amendment is a right of self-defense. And if that doesn't include a subjective component, then there is no right of self-defense. So that's your subjective experiences, your subjective understanding, your subjective interpretation, and the rest. Now, that isn't the final end of it. That subjective action still has to be objectively reasonable in the minds of the jury. We're not challenging that aspect. We're just saying that to completely obliterate every subjective attribute obliterates self-defense, because they're treating him like it's like as if he was the Rock and a bunch of little kids were annoying him and he brandished a gun.
That way, or that, as exercising self-defense, he went out and actually open fire. I mean, you can take a more extreme example where someone's gonna say it was self-defense. I feared for my life, like the guy who shot the Trump supporter in Portland. I mean, yeah, self-defense. If in your mind someone's political affiliation is an immediate threat on your safety, versus people literally chasing you down, taking swings, saying go get him, and we're in different realms. One is irrational fear of self-defense, even subjectively justified to the person. The other one is subjective but totally justified and reasonable and to be expected under similar circumstances, and to not factor in specific elements of the individual on the one hand with the entities at issue, and also with historical abuse. Yeah, it's I mean, you're preaching to the choir. People in the chats are just saying, I hope you get a fair shake at the Supreme Court if they even decide to read your cert.
They do. I know this from range of sources. They read all the petitions for cert, particularly if it's a decently written petition for cert, it will get circulated. And if it's a creative idea, I'm also using it as an opportunity. A lot of law clerks helped out in drafting the cert, is to teach them legal writing through a real case. And part of it is use cite policy examples, cite that so in our petition for cert, where we cite international legal standards, reinforce this idea of self-defense being a core human right that's constitutionally enshrined. State courts, of course, have supported this over hundreds of years. History has supported this, empirical evidence that it's supported by a wide range of data. But citing a wide range of academics, historians, logicians, and lawyers in a wide, beyond just a national scope, to sort of reinforce and reinform the policy that's there. And mostly it's just to lock into their head the idea. They will all get this idea by the time they finish reading it, whether they take any action or not. They will get the idea in their head. The Second Amendment is about self-defense, and that means the Second Amendment informs the interpretation of self-defense everywhere, as state civil law, state criminal law, torts, statutes, you name it, regardless of whether even a gun is used. And that's the part of the mindset I want people to start sort of thinking through. If somebody uses a knife and they're denied a right of self-defense because their subjective interpretation and understanding is all excluded as evidence from trial, to me, that's much a Second Amendment violation as when someone uses a gun to defend themselves. And so I want to have the Second Amendment be a constitutionally recognized right of self-defense, which must include some subjective components moving forward. And it's the beginning of that process. And it starts by writing petitions for cert. But I'm not tied up with whether the SCOTUS gives us relief or not. It's about getting that conversation going so that we can have lasting difference. And it's thanks to people like Michael Strickland who've been willing to fight the system all the way through to give us the opportunity to even have the argument presented.